The question is that the motion be agreed to.
Mr.
Jacinda
Speaker.
Ardern.
Mr. Speaker, thank you for the call and for the Minister's contribution to the discussion. Of course, this Act, which is now split into 23 separate bills, has been a long time coming. In fact, the Minister took over this bill from her predecessor, and some elements of it have certainly changed along the way, some as recently as in the last stage of the bill's debate. And I will touch on that a little further on. But I do think it is important to add to the Minister's vote of thanks, because particularly officials within the Ministry, but also PCO, this has been a significant drafting exercise, and we all, regardless of the various positions we may have taken on elements of the bill, they need to be congratulated and thanked for the intense work that would have gone on for the Judicature Act. It is 100 years old, some of the legislation that we are amending here today. So there is no doubt that the work needed to be done. In fact, the Law Commission's work was several years ago when it recommended that we consolidate the Courts Act with the Supreme Court Act. So I absolutely agree it's long overdue. But there were elements of that merger that meant that we lost some really critical parts, some critical principles, which I want to touch on. We also lost a few opportunities. Now, look, we started this debate several years ago, but actually, as we've gone along, there have been additional questions of legal reform that have come up. For instance, the work on by the Law Commission on alternative trial processes for sexual violence. That has produced recently a number of recommendations that could have been picked up in various pieces of work that were already before the House. This bill happened to be one of them. There was also the Evidence Act. There were various vehicles that could have allowed us to expedite some of the work that needs to happen within the justice reform area, which still wait this Parliament's consideration. So a little bit of a lost opportunity there, but perhaps more so for the Evidence Act. Because we do know, for instance, that while this bill repeals the District Courts Act and makes a unitary district court, where the specialist courts will become divisions of it, so then the Family Court, the Youth Court and the Disputes Tribunal will sit under it. Part 3 enacts the Judicature Amendment Act of, originally, as it was set out, enacts the Judicature Amendment Act with updated language. We've then got the incorporation of the Law Commission's work on aspects of damages. This obviously was an omnibus bill, so we did have some opportunities that weren't taken up. But as I mentioned earlier, I want to speak to the elements that were lost in the merger, as it were. So I mentioned that the Supreme Court Act 2003 was one of the acts that was brought in under this piece of work, and some of those principles, like for instance the original principle around the Treaty of Waitangi, has been amended. Originally it was lost altogether in this work, and I want to commend the Māori Party, because actually I think it was their lobbying that saw that provision go back in, but not all of it. So let me just clarify here that originally within the Supreme Court Act, one of the clauses included enable important legal matters, including legal matters relating to the Treaty of Waitangi, to be resolved with an understanding of New Zealand conditions, history and traditions. Now, that was dropped. What was put back into the bill through the work of other parties was simply enable important legal matters, including legal matters relating to the Treaty of Waitangi. So we did lose half of what would have been, I'm sure, a really robustly debated clause from the time that the Supreme Court Act was passed. So that is obviously disappointing and strikes me as an unnecessary omission from this bill. Secondly, as was canvassed in the newspaper yesterday, the Herald covered off the fact that we have in the bill basically created compulsory retirement for judges. Now, there are very few areas where you could justifiably have compulsory retirement, and most are usually based around careers where there are certain levels of physicality. But it does strike me that we have used an age as the arbitrary guide to whether or not someone still has the competency for their role. Age is a very arbitrary measure for that. There will be a range of professions where people, regardless of their age, may need to be moved on for competency reasons. I don't want to comment on Parliament as an example of that, but my view would have been that if we in this House were debating how to ensure that we always have the robust instruments to ensure competency, we wouldn't pick one measure and use that as a way of dealing with it. So for the judiciary, it strikes me that if we need to remove people because there are competency issues, we need to make sure that we've got the powers to do that, and to make sure that we have that flexibility as required, and age isn't the best marker and determinant of that. And so we saw that as being arbitrary. Secondary to that, of course, it's discriminatory as well, and we sought to have that removed it's such a danger zone to move into examples. So I'm not going to, despite the Speaker trying to entice me down that dangerous track, I won't be doing that. And so I'll just leave that as that. One of the other elements, and I have to really reflect on this, one of the other elements of the bill that was removed in the last stages was the provision that said basically we would be publishing all final written judgments. Now, that was removed at the 11th hour, basically. Now, we asked the Minister for some rationale. They came back with basically the rationale was the scale of producing all written judgments in that manner was just massive. It would be costly and would require immediately for new staff to be hired, and basically courts weren't ready for that. So our view was, okay, well, let's give you time. Let's put in a time frame for that SOP to come into force that's longer than the enactment clauses for the bill itself. Unfortunately, that was defeated, although I think it had a quite wide support in the House. Now, I just went back and had a look at the statement that was put out by the then Minister of Justice at the time this bill was brought before the House. It was the 27th of November 2013, almost 3 years ago. And one of the primary reasons the Minister said she was introducing this bill, was then Judith Collins, was to build a more customer-focused, lower-cost, more accessible justice system. And let me reflect on this statement. She said, the bill includes changes to ensure all written judgments are published online, unless there is a good reason not to. It also places a requirement on the judiciary to publish information on the number of outstanding judgments. New Zealanders are paying for this justice. They should be able to access it. The higher courts already publish decisions of interest, but the biggest gap is the district courts, where the bulk of cases are heard. We must work with the judiciary to close the gap, and this bill is a key part of that dialogue. People have the right to know. Most of this press statement was about the publishing of online publishing of judgments. Most of the rationale that the then Minister of Justice gave for this massive bill was something that was removed by this government at the very final stages of the bill. Now, that again, I just wanted to highlight that seems a massive loss. We understood the timing issue, but we absolutely believed it would have been possible to deal with that. One final word. Making the justice system more accessible, the use of electronic filing was a theme in this bill. I have heard recently changes that, for instance, have been used in the family court around electronic filing and the timeframes which lawyers must have documents filed with the court have become so explicit. They've lengthened the timeframes, of course, that things must be filed by, because there had been issues with judges not receiving them in time. That's fine. If you are a minute late on that long lead time, those documents will not be passed on to the judge hearing your case, and you'll find yourself, when you're before the court, having your hearing postponed. Or you will see frequently documents lost in court and cases postponed because of that as well. Now, I urge the officials from the ministry, sit at the back of a court for a day, and you will see the inefficiencies we have at the moment because of the way our filing is working, the frustration from officials and registrars. It is cramming up our system to an unbelievable degree, and there's no documentation of it, so it is hard for this House to scrutinise, but it is a massive problem, and I really ask ministry officials, engage with the legal fraternity on this issue. It is denying people timely access to justice, and this presumably was what this bill was meant to be all about.